Now, the judge granted a motion by the prosecutors to dismiss the first charge. So that's out now. People are misunderstanding what the judge said. They said, no, he added a charge. No, he gave what's called an Allen charge, not a charge like one of these counts. It's an instruction to the jury. It's also called a dynamite charge. It comes out of a Supreme Court case from 100 years ago, where he is allowed to say to them, hey, go back in there and give it your best effort and be open to changing your mind. And try to come to a conclusion. The concern with the Allen charge is that you make them come to a conclusion that they're not comfortable with. So then they still can't do it. The prosecutor comes and says, get rid of the first charge. So now the judge says, come back Monday, deliberate on the second lesser charge, criminally negligent homicide. The judge told the jurors, what I'm going to do is this manslaughter in the second degree is dismissed. Remember, the DA was okay with this. So why did he ever charge him with it in the first place? You are now free to consider count two. Whether that makes any difference, I have no idea, but I direct you to focus deliberations on count two, render a verdict on that one. The defense then asked for a mistrial, strongly objected to the dismissal of the charge, right? Saying this was essentially elbowing the jury to reach a compromised verdict. The defense also raised the question of whether or not a juror spoke to the press. Could also be grounds for mistrial. So what does it all mean? Trial attorney Misty Maris, defense attorney Arthur Aidala, jury consultant Susan Constantine. Thank you each and all. Susan, I start with you, asking what is a reasonable person? Am I right about what that could be suggestive of in terms of the state of play in the jury room?
Yeah, so, those jurors that are in there deliberating, they're thinking, what would you do? Okay, what would be reasonable under that situation? Because most of them are traveling on that same train every single day. So what's happening behind closed doors is there certainly is a split. There's no doubt. We've got one extreme that guilty, right, for manslaughter, and then you've got others that are on the complete far right versus left. So now what's happening, I don't know, I would think that the jurors be a little bit confused because I've never seen this happen before. Now they've got to go back and then have to go and re-deliberate again. And hopefully they either come to a compromise or we're just going to have a hung jury again.
Arthur, you and I have talked about this a lot. What do you make of the suggestion of this is bad for Penny, man? This judge is basically telling them that this is come back and try it again on this, and they're throwing out the other charge, and this guy should be walking away. He did what we want people to do. He got involved with a bad guy. The two other guys were there. They didn't seem upset by what Penny was doing. Why would it be reasonable for him to see otherwise? This is a bad day for Penny.
I'm going to look at the glass half full. When they ask for the reasonableness, it goes to the two-part test of regarding self-defense. And that comes out of the Bernie Getz case. Would a reasonable person, number one, does Penny feel threatened in that situation, so he's entitled to self-defense? And then the second part is, would a reasonable person in that situation feel threatened and can act in self-defense? So they're struggling with the self-defense. And here, Chris, is why I'm going to look at the glass half full. If they're struggling with self-defense on manslaughter in the second degree, it also applies to criminally negligent homicide. And they were told, if you can't agree on manslaughter, you're not allowed to look at criminally negligent homicide. The prosecutor took the unique, it's never happened before that we can find in the record books, saying, Judge, it's okay, you could dismiss the top count. Because they're dismissing it and he's allowing it, there is no appeal to that. Now Penny goes from a maximum of 15 years to a maximum of 4, so he could go to bed tonight knowing he's probably not going to jail at all. And now those jurors are going to come back on Monday, and if there are still some jurors who believe he believed there was a fear and a reasonable person was in fear of their lives or someone else's life, he acted appropriately, it could still be a hung jury.
Misty, make a smarter point.
Well, truthfully, Chris, Arthur's spot on, and I do think that the jury is grappling with that justification defense by virtue of that question regarding the reasonable person test, and that would apply. So it's not going to matter whether it's manslaughter or criminally negligent homicide. If that's what's creating the deadlock, then the deadlock will exist for criminally negligent homicide too. But the reason that the defense was adamant and asking for a mistrial when the deadlock occurred as opposed to dismissal of of the charge and the reason the defense objected is because it's teeing up the case for a potential compromise verdict.
Hey, thanks for watching. Go to joinnn.com to find NewsNation on your screen. And don't forget, click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.